don't see a lot of radical-minded people seated on federal juries because of the broadness of jury pools and jury selection protocols, because of the amount of preemptory strikes that prosecutors have, because of the screening process, because of the broad nature of being able to disqualify a juror for having, let's say, radical or strange ideologies. You're not really going to see that. So, we might see on the internet a whole lot of people trying to lobby for, what he did as some sort of justification, but you're not likely to see a jury that's willing to tolerate that.
Interesting. So, Danny, you're new. What do you think, man?
Oh, I'm sorry. About Mangione, I haven't really been following it. I saw that one of my mutuals is in here, and I haven't really been following the case too much. Hey, Meredith, how are you?
Well, no worries. That's all good.
But obviously, I imagine it's probably really interesting, and that you have like one half of people that are like, however he should be prosecuted, but then you have another side that they're like, he's a hero and stuff like that. I wouldn't say he's a hero, but you look at things, and unfortunately, my mother had a near-death experience about 5 weeks ago. And, at her house, like, the mail kept piling up, and you see bills and bills and bills from her stay in the hospital. And just last Wednesday, she was taken to a rehabilitation center where she'll be for another, at the low end, 8 to 12 weeks, higher end, 16 weeks. And, the amount of money, for health care, whether it's the most tiniest little thing, doctor visit, to overnight stays or extended stays in ICU or whatever. It's crazy. So I don't know. It's just really weird. A lot of different feelings about it from so many people. Just really, really interesting.
That's pretty cool, man. Jeremy, what do you think of this? I imagine you may feel a little different than I do, but I definitely think the guy deserves the death penalty.
Yeah, I'm generally against the death penalty, not on moral grounds, but on the fact that I don't think anyone has a perfect justice system, and the permanence of the death sentence, and the fact that especially within the U.S., it typically costs a lot more in the U.S. to kill a man than to imprison him for the rest of his life, right? But having said that, I typically, in a case like this where there's no doubt that he walked up and shot that man in the head,
So I had a question about the appeals process, though, because I'm not familiar with it. Like, is it harder in a federal case like this with the Department of Justice doing this? What would the legal challenges be in a case like this with the final sentence with the appeals process?
So the federal court appeal system is more complex than any of the state systems. You have broader opportunity for appeals. You have a broader density of appeals. And so you have a number of things. Let's say your defense attorney does everything perfectly. It is the best defense anyone's ever seen, and they're just amazing. This is perfect, right? Which nobody gets because that's not how trials work. But let's say this defense attorney manages to pull out all the stops and you get the Super Bowl of defenses. That's going to take out about 20% of your general claims, right? A lot of appeals claims come into the defense attorney dropped the ball. They failed to provide substantive counsel. They failed to get something introduced. Then you have another 15% of appeals that are going to come in and say the judge did something wrong in terms of protocol or process. Or, the judge didn't allow something in to evidence that they should have as a submission. They didn't allow full breadth of testimony from an expert, right? Most expert testimony gets limited, and the general public doesn't know this unless you work in the field. When you put an expert witness up there, you've already told the court what you want to ask that person. You've already told the court the general framing of why they're being called. And the court allowed to do and what you're not, to make sure that you are sticking to what's relevant. And then you have another 10 or 15% of the appeals that will have to do with what the prosecutors did, right? Did they break the law? Did they violate something? Was there something admitted that the process, the evidentiary chain was broken from the police to the prosecutors? There's all of these protocol and base challenges that come into appeals. Then when you have a death penalty, you're always going to have a habeas petition filed at some point. They're going to challenge the validity of the death penalty. This happens in every single case. And given the way the federal government works, under President Biden, we had a moratorium on the death penalty. And before he left office, he commuted the death sentences of a significant number of people on federal death row. Pam Bondi and Trump just last week lifted the moratorium, which is what's allowing her to direct her office to pursue those charges. So you have all of these different reasons that you can appeal for, and you can appeal individually in a line item nature in federal court. In state court, you issue all of your reasons you're appealing at once. In federal court, you can take individual bites at the apple for every single thing you're claiming you have cause for. So a lot of the time what will happen is they'll file an appeal on a number of grounds targeting the prosecutor's office, and they'll see if that works. And when that gets shut down, then they'll file a secondary appeal, saying that the judge did something wrong. And when that gets shut down, they'll file a third appeal. And the structure and system within the federal courts allow for this broader and longer appeals process that can take years, which is why when the speaker earlier was speaking, I don't see him on the stage anymore, but when he said, it's very costly for us to do death penalties, a death penalty inmate costs us, almost twice as much as an inmate you have on life. And it's because we have different housing requirements, we have different standards, they have different rights to appeal before transfer, they have to stay within a certain distance of the court through their entire appeals process. And so it's a lot more costly for us if somebody is dragging their appeal out. If you are in state court, you can burn your appeals out in about 2 years. With a good attorney in federal court and a complicated case, you can have 10 to 12 years of appeals before you're out of your reasonable appeals. And so, even if she gets a death penalty conviction on this case, I don't see him having a lot of grounds for appeal because, again, the evidence is very clear, the submissions are very clear, there's video, there's his own words, there's, a lot there that would negate a lot of the appeal issues unless during the trial the judge fucks up or the attorney overreaches. Like, usually you have to wait and look at the trial to really judge if there's going to be a valid appeal because that's what you're appealing. You're appealing the protocol and the situational dynamics that occurred during the case. You're not really appealing the conviction as much as you're appealing how the conviction was crafted and how they got there. And, a defense attorney is trying to pick that apart in a way to get it thrown out. But the federal appeals process always takes, 3 to 10 times as long as the state appeals process.
That's super interesting. Hey, Frank, I saw you come up. What do you think? What's your opinion on this whole situation? Frank?
I can't talk. I'm just listening.
No worries, man. Dr. Adams, I have a feeling I know where you're coming down on this. Go ahead and tell me anyway.
Hey, Adam.
God bless. Hey, what's up, y'all? God bless Pam Bondi. I think that, she is absolutely spot on. He deserves the death penalty. It's terrorism. We get the death penalty for terrorism in America. So, I say more power to him.
Alan, how do you feel about it?
Well, I'm driving. I can't pontificate, but you're fried the bastard. Thank you.
Marshall, should I be like a devil's advocate here to spice it up like Kelly always says, add some paprika?
Even if you like, I don't, like if if you want to be the devil's advocate, please go ahead.
No, it just has been funny.
I mean,
Between Adams and Allen, it was just funny. Sorry, Greg.
no, you're good. The thing about cases like this is, and this is the thing, when we're talking about the media coverage, you can say like Chancey did, oh, well, people are split in half, blah, 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 blah. When it gets into court, you know, this guy isn't going to be framed as a CEO or a big corporate evil person. This is a 50-year-old man with a wife and teenage kids, right? This is someone whose oldest kid is supposed to graduate high school this year. And, you know, dad got shot in the fucking head and is dead. This is someone whose other kid is going to graduate in 2 years, right? That's weddings he won't go to. That's babies he won't see. This is the piece that people miss, is that the human aspect is a huge part of what the trial is. And then, as Adam said, what he did is terrorism, right? It's tantamount to terrorism, whether they charge him with terroristic charges or not. Your entire goal and motivation was to kill somebody in a position of power in an industry to terrify everybody else in that industry because you don't like what they're doing, right? Your goal in killing this person wasn't killing them because you hate them. It wasn't killing them because they were the doctor who, you know, performed the surgery on your mom. It's this guy is a figurehead for a major healthcare company and therefore was a totem for the health industry and corporatization in America, and you want to shake that to the core and scare the shit out of people. That's terroristic activity. That's your whole purpose and your goal, which is why the federal government can step in. That and murder with a firearm for purposes of public terror, it is a charge of terrorism. Now, I don't think Pam Bondi's going to have them charge him with that because they don't need to, right? They can simply charge him with the murder with the firearm, point out what he did and why, and get there a hell of a lot easier than risking pissing, you know, very particular jurors off with using terrorism charges. But it's tantamount to creating public terror. That's the goal of killing somebody like that, right? Because killing that one individual, you know, the company mourned and then replaced him, right? This is the thing that we all know when it comes to your workplace. Your workplace will mourn you and before long replace you with somebody else to do the exact same job. And so you're not really doing anything with this but trying to terrify an industry, trying to make a point in a very horrific way. But the trial is going to be honed in to what you did, right? You took a life of a human. This is a husband, this is a father, this is a brother, this is a son, this is a neighbor, this is a guy who was involved in his church, this is a guy who was involved in the Boy Scouts of America. Like, you end up in a very different conversation in those trials than you do, you know, broad news pontificating of, oh, well, this guy had such a horrible job, he deserves what happened to him. That's not the narrative that's going to hit the courtroom.
I have a question. Oh, go ahead, Alan, you're driving.
Oh, yeah, but I was going to say, don't you, when you open up, characterize making appeals to his character as well, he was a father, he was in the Boy Scouts, etc., doesn't that open up the defense to, oh, well, yes, he was a father, but, oh, here are some documents from the company that showed he screwed 100,000 people who had cancer out of their treatments, and he was an evil person, and speaking about the character that way, and then, you know, framing it as, this isn't about a murder, it's about justice.
Okay,
I mean, if you had a judge willing to let you do that, yes, and in state court, you'd probably get away with it. In federal court, I don't know a single judge who's going to allow character assassination like that of somebody who's dead, right? Because by federal standards, if you're engaging in character assassination, that person is not alive to defend themselves, and the court is very rarely going to be okay with that happening. You would also be very close to HIPAA restrictions and HIPAA guidelines because, you know, thanks to the way our corporatized system views things, you have two problems with getting those internal documents admitted into court. One, they're going to be the intellectual property of the corporation. And so unless the corporation wants to give those documents out and specifically show this is the gentleman who said yes and this was his vote in the board, this is what this is, if the corporation is not cooperating and giving you that, you're probably not going to get your hands on it in a way that is legal to submit to the court, right? You might get your hands on it in a way that you can present it to the public and leak it to the media, but you're not going to get your hands on it through first source material requests, which is what you need in order to put something into evidentiary submission in court. So you're going to have that problem. Second is the costs, the rejections, the acceptance of healthcare tied to your insurance also ties into HIPAA. And so even if the company kept a record of 100,000 people were denied, you would have to have already gotten the release from those people or their families to utilize a statistic that they were included in order to get it into federal court. Right? State court would allow the statistic without the names. In federal court, you have to be able to show the secondary proof of submission to show it's a real statistic, which means you'd have to have the company vouching for it, and you'd have to have the sign off of all of the people that you're trying to reference. And so the odds that you would get your hands on that material to submit it into federal court, only 3 states have the same level of requirement of evidentiary submission as the federal government, right? And that's Florida, Texas, and in some cases, California. Most other states have a much lower threshold. So in a state charge of murder, you're going to be able to let your defense attorney do a lot of that. In a federal court, they're going to find their hands tied, and they're going to find the judge restricting those evidentiary submissions because we have different restrictions on victim character assassination, right? If you want to frame the company's motives and the company's behavior a certain way, and you can back that up, that's fine. Because this guy is dead, you are not allowed to besmirch a dead person in the same way unless there's a direct factoid that negates that protection, which again, I don't have a pile of evidence in front of me. I don't know what they're going to try to submit or not. But it's also not considered a character input to point out that, you know, this was a guy who lived in a normal town, he had kids, he had a wife. That isn't a claim of character, right? And the only way you get to rebut someone's character is if it's introduced in relation to a particular choice. You know, so if somebody was suing the company, right, not killing this man, but they had sued the company and they brought him in and were trying to, you know, force him to testify, that could allow that framing, right? If he was a witness in a case, then yeah, you can definitely say, hey, aren't you paid an exorbitant amount of money? Don't you have these things? Didn't you make these decisions? Didn't the board make this decision? But because that's not what this isn't a civil case against the company he worked for. This is a murder case about him being killed, him as the human, right? So you don't get to pick out the pieces of the human you didn't like and try to put them under a microscope unless your attorney can find a way to make it relevant to the justification of what you were doing.
Yeah. I mean,
Doing that.
I'm thinking of all the ways that defense attorneys will I can't say it now, obfuscate the actual point of a trial and make it about something else. So with the O.J. Simpson trial, it wasn't about a murder, it was about the police framed him because he was a black man. That's what the trial became about. And I can't help thinking that maybe my example wasn't a good one, but the defense, and again, I heard your distinction between state and federal courts, and they may have their hands tied, but they may try to make it about him and healthcare and policies, etc.
Oh, 100%. I mean, they're going to have to. The thing for him is that in order to have any sort of defense for what he did, they're going to have to go one of two ways. They're going to have to go mental illness and diminished capacity, which my understanding is not the way they're going in the state charges and likely not the way they're going with this, or some sort of loose leaf justification, right? And loose leaf justification, again, in state courts, you have broader access to make those claims and get them in. You could still do it in federal court. I'm not going to say they won't attempt to muddy up the victim because they're going to have to, right? You don't have, this isn't a, battered wife who stood up to her husband finally. This isn't a victim of sexual assault. You don't have a built-in narrative that makes this person sympathetic, so you have to create one, right? The defense attorneys are going to have to try to create one. Now, this is also going to be one of those cases that any defense attorney worth their salt will tell you, they're not always trying to win, right? Sometimes they're simply trying to create the best defense possible to leverage a sympathy verdict or to leverage a better sentence for their client, right? In this case, in federal court, he's already cooked. I can tell you now, I don't have to see the jury, I don't have to be there. With the evidence that is available to the open public, he's cooked already. Like, I don't know how you would get a federal jury to let him off, but the defense is going to be trying to get him avoiding that needle, right? That's going to be their goal at this point, with Pam Bondi being very clear she's coming for him, and she wants to make an example of this behavior, and she's treating it as terrorism, though she's not charging terrorism. The defense is going to be trying their absolute best to create a situation where the jury is willing to make a recommendation to the judge and say, hey, we really think he deserves life in prison for what he did, or, due to the stress of the system, this personal experience he had, they're going to be fighting for a lesser sentence, not so much a not guilty, right? Like the OJ case was an example of using public discourse and trauma at the time to try to get that client off, right? Like the defense for OJ was, we don't have good odds of him as a black man getting a life sentence if he's convicted, so we better get him off for doing it, right? That was your option. In this case, they know they're not going to get him off. They're not going to get a jury of 12 people in federal court that is seated and here's the evidence to, through a legal preponderance of the evidence, say he's not guilty. Even if you could get a sympathetic jury seated who found him not guilty, a judge is going to set aside that jury verdict, vacate it, and issue their own. Because the evidence is so clear that you're going to have a very, very small, almost impossible window that you would be able to convince a jury and have that jury decision hold up before the judge. Because the piece that people miss is juries are not allowed to simply consider everything they want to, right? The court tells you what you can consider and how you can consider it. And the court tells you to exclude certain things from consideration. And people go, oh, well, how's the jury going to do that? Well, the check and balance for the court is, if the jury comes back with a not guilty, and there is not a reasonable way they could have gotten there by following the instructions of the judge is well within their rights to set aside the jury verdict, either dismiss the case without prejudice so it can be refiled, or simply input their own. And in federal court, you will often see judges, not often, but when this comes up, when you look at the amount of times this comes up, federal judges will, more often than not, vacate the jury decision and issue their own from the bench. And then that gets appealed, and the appeals court decides whether or not the judge was correct or not. But that's where this is headed, is into a fight over what type of sentence he gets, not if he's innocent or not.
It occurs to me that another option too is to somehow get a hung jury, so that it's not the ideal situation, but it's a stall at least. That okay, we went through all of that, and then it gives the defense it gives them both a second try. But I remember hearing that it's better for the prosecution. Second time around is better for the prosecution. Was what I heard, but I could be wrong.
Yeah, the only time it's really beneficial for a defense attorney is if you had a judge that was particularly ornery or particularly engaging in a way, and the other judges who could be selected for a repeat trial, right? Because what happens is you don't necessarily get the same judge. You could, but it goes back onto the system for the randomized selection of what judge gets seated when you have new charges filed. So it's not like the case will automatically go before the same judge. There are situations where it will. In state courts, it often does, especially if you have the senior judge to begin with, because they'll just select the case and give it to themselves. But there are situations where they can go, hey, we had Judge Adams, and odds are 1 in 15 will get Judge Adams again. And 8 of these other judges would have been better for us because we can now argue the things Judge Adams said no to. Because when you go back to court, you have to resubmit everything. And so when you go back to court like that after a jury nullification or a hung jury, and the judge, dismisses the case, issues the mistrial, and allows for it to be brought back and retried, everything you had the judge set aside last time, you have to ask this new judge. Every bit of testimony you submitted, you have to do again. So you get a second bite at the apple. The problem for the defense is the defense's win is usually in catching the prosecution off guard, or getting a lucky yes on something that nobody was expecting them to get a yes on. Like you got witness testimony in that was gray area, you got audio tapes that wasn't clear, something that the chain of evidence was broken on, was allowed to be admitted due to an access rule. Like there was something specific that you didn't get the first time that you're like, oh, I could try to get it again. And in death penalty cases, it usually has to do with election cycles for federal government. What I mean by that is, if you knew you were at the end of a Trump term and you were likely to see a Democratic president, you're going to stall for everything you have in your life, because Democratic presidents do not often allow death penalty cases, right? They'll either issue a moratorium like Joe Biden did on carrying them out and sentencing people to them, or they'll simply instruct their people not to go for them without the moratorium. So if this was a different period of time, maybe you try for the nullification so that you hope your next trial is dated into a new administration that isn't going to seek the death penalty. I mean, usually nullification has to do with you're hoping for a second bite, you're hoping for a different jury, you're hoping for a different judge, you're hoping you can get something admitted or excluded you didn't. But most of those things benefit the prosecution more than the defense on a basic coin flip. And so, it's not a lot of situations where the defense is like, hey, a hung jury is a great option. Now, it's probably better than a guilty verdict with a death penalty. I'll take having to do it again. But also, in certain cases, you're hoping that the prosecution, through public pressure or political expedience, doesn't want to waste the resources to try the case again. The federal government will try him 10, 15, 20 times if they had to on something like this. This is essentially an act of public terror. You killed an official in a capacity to terrify an industry. Like, they're not going to say, you know what, that was a hung jury, let's not waste the resources and do this again. They're not going to do that, right? This isn't a case where you see a police officer kill somebody and it gets a hung jury, and then the DA goes, do I want to go through the embarrassment of doing this again? That's not this type of case. So, it all depends on
the kid literally walked up to a dude and shot him in the back of the head. Like, the video is, the evidence is so clear and so overwhelming. Yeah, I'm with you. I don't see how anybody can come to a different conclusion.
And it's not to say you won't have people who want there to be a justification there, right? There will be people who look at the corporatism of the country, and this guy being someone who made millions a year setting policy of a healthcare system that causes people to not get care, right? A lot of people in this country feel that way. And so you have an ability for a story to be framed that way. It's why the media does what the media does, right? But it's different when you hit a courtroom, and it's different when a jury is seated. And so, you end up with a different reality. It's not to say people won't want this to be something different than what they have. It happens a lot of the time where, people want something to be more clear-cut. They want it to favor their worldview, right? They want there to be a justifiable reason that this, corporate elitist got his head blown off. But at the end of the day, in this particular case, you don't have a lot of gray. You don't have a lot of, subjective material. you have a very educated and disturbed young man who took it upon himself to get his hands on a firearm and go assassinate an executive of a healthcare company. That's not, there's not a lot of gray there.
Yeah, I agree with you. If only we could find somebody who believed the opposite. I've talked to people on Clubhouse who believe the opposite, but apparently they're just not here.
I still think that. Can you hear me okay?
Go ahead,
Okay,
Miriam.
Oh, I still think though, and thinking back to Danny, he had to leave, but you know, he was talking about his mom and his mom's bills. So even during jury selection, I can't think of a single person in the United States that hasn't been impacted by rising healthcare costs and bills and all those kinds of things. So I agree on the one hand, and this is me speaking with a non-legal mind, but from the PR optic side of it and the way that informs like just the psychology of decision making in people, I can see, yeah, it's easy. Like the videos are there, the statements are there. It's a clean cut. Like this is what happened. So nobody's necessarily disputing what happened, but I can imagine though that when jurors are sitting there, they're also reflecting back on the impact of these things on everybody's lives. So I kind of also do wonder what like the insanity side of it, like, you know, we always talk about activists, and activists are just, they've gone crazy, or, you know, people say a lot of things about activists when they're just in their rah mode and screaming and hollering and petitioning and boycotting. So I can see how that can manifest even into a more like crazy psychosis level, enough for somebody to do something like that, essentially in broad daylight, you know, really just like as egregious and just in your face as possible. It's done. And so no one's disputing that, but I do wonder the impact of that, of the way that we engage with these things and how personal it touches our lives.
Well, one of the things that I can guarantee, and I'm speaking very specifically to the federal trial, right? Because state trials are very different, and the strategies of the prosecutors will be very different. In federal court, you are allowed to ask in the jury questionnaire, and people don't understand this who don't know the court system. So if you work in the court system, bear with me, because this is for everybody else in the room. There isn't a standard set of jury questions that are issued, right? The defense and the prosecution will cobble together what they want to be the questions on the jury questionnaire, and that will become the questionnaire that's issued. And so a judge can limit that and say, hey, you know, I want this down to 2 pages. I want it down to 35 questions. You know, we want this to be narrowed out. Certain questions can be disqualified for being too close to the gray areas, what you can and can't do. But there's some basic ones that I would almost guarantee will be on the jury questionnaire of, do you or your spouse have health insurance provided from an employer, right? And the prosecutor is going to try to exclude anybody who doesn't say yes to that. Step 1, the goal is going to be to make sure you have a jury full of people who get their insurance from their employer.
Good point.
You want school teachers, you want union workers, you want healthcare workers, because people who have their insurance through their employer generally have slightly better insurance. And I'm speaking from California, where frankly, even people on ACA plans here, we have phenomenal health insurance access in California. So California is kind of an awkward state. But overall, federally, you're going to look at it because if somebody works for the government, they have good health care. If somebody works for a hospital network, they have decent health care. You know, and those are the people.
You fucking kicked me.